favor of extraterritorial jurisdiction in precise occasions such as the one concerning an armed conflict in the east of the Democratic Republic of Congo. My colleagues who will speak tomorrow will be able to show this court that with regard to admissibility, the initial claims of Rwanda consisted in rejecting the admissibility of the application in spite of the exhaustion of local remedies. Now, on this same issue, the trends followed by Rwanda, they talk about latest pendants under international law, that the matter is pending before another commission of vice president, honorable judges. We can give you the symptoms which the DRC is indeed facing, and Rwanda has always tried to give a different impression or let the situation be put under total silence. But there is a very about this case which to Rwanda is embarrassing. In this regard, it is important to note that in its reply to the objections raised by Rwanda, page 24, paragraph 58, Congo talked about genocide against the people of Mindo, and this is indeed a psychological problem for the Kigali problem because of the acts which it is perpetrating in the east of Congo. This was noticed in its reply, page 22, paragraph 58. They tried to mobilize a position to impress a group of experts of the United Nations in May 2024. The experts who were mandated by the United Nations confirmed once more that the M23 and the Rwandan Defense Forces continue, and I quote, to steal from the people, and in particular the Hutu, who are considered as close to the FDL. And these are the reasons they claim that they are present in Congo. They steal from the villagers, they loot from the people, they take all of their property. And it's important to add that the fact that the DRC, in its reply on page 30, paragraph 54, talked about the responsibility of Rwanda in the massacre of Congolese on the 25th and 29th November. These massacres is indeed a situation of ethnic cleansing. Honorable Vice President, it is difficult from this point of view to deny the fact that massive and flagrant violations of human rights have been carried out in the Congo by Rwanda, and this can only be justified by a genocide plan which is well planned and elaborated systematically and with determination from Kigali. As a matter of fact, the concretization of this ethnic cleansing of some civilian population, and some of them are indeed targeted populations perpetrated by Rwanda, they are indeed localized within a geographical area which is identified. And these are cases of flagrant and massive violations of human rights perpetrated in the east of the Republic of Congo. Let me come to the next item of my advocacy to talk about the demonstration in the Democratic Republic of Congo. Mr. Vice President, let us recall that the Rwandans are trying to follow an approach which is deceitful, and this is trying to draw an advantage from a judgment, and in this case they want a decision which will lead to cover the confusion which they have created in the Democratic Republic of Congo. In other words, Rwanda presents arguments which contradict themselves to the extent that a language specialist will call this a pragmatic destruction of facts, and this is contained in their analysis and in their intention to shift attention from the realities. Let us limit ourselves to a few examples. 3 agree at this juncture so as to illustrate what they have just said. First of all, it concerns their position on the armed conflict between the two countries. The argument that Rwanda presents is clear because it is nothing but solipsism. They try to talk about sophism, as I would call it, and Rwanda claims that it is a matter of peace and security in the east of the Democratic Republic of Congo, as is stated in paragraph 58 and paragraph 145. They claim that the fundamental issues of Democratic Republic's problem is territorial integrity, peace, and security. From their reasoning, it is prepared from a negative perspective in paragraph 48 in their preliminary objections. They claim, and I quote, that the applicant has failed to show how this case will indeed solve the problem of an armed conflict and how this could be dealt with by an extraterritorial jurisdiction. In their conclusion, in paragraph 35, paragraph 107, I quote, it goes without saying that the respondent state wants such a conflict and they will be held responsible for all the problems in the east of the Congo, and therefore there's no armed conflict which will prevent the applicant or the people they represent from exercising local remedies. Honorable President, there's a flagrant contradiction here, and without any further ado, let's look at Rwanda's reply. On page 35, paragraph 101, there is the quotation from President Paul Kagame's speech, where he talked about the presence of special forces of Rwanda in the Democratic Republic of Congo. So how can we not talk of a conflict between the two countries? Now, this is contained in the media across the whole world, and the facts of the applicant are corroborated in the fact that Rwanda is present in the east of the Congo. The contradiction concerning the claim of incompatibility of Congo's case with the Constitutive Act of the African Union leads to confusion in the manner in which they present their arguments. Look at page 21, paragraph 64. We'll come back in details tomorrow when we really want to show that there's no logic in the case presented by Rwanda, and we will be referring that they are indeed going out of context before this court. Thirdly, there's a problematic nature in the manner in which Rwanda refers to the diplomatic issue, and it goes against the principle of coherence and rigor. In short, Rwanda itself, and I quote, we're in paragraph 44, Rwanda says that the respondent state's position is not diplomatic, but there are similarities when it comes to traditional diplomatic protection, which follows the rules, and these rules should go through exhaustion of local remedies. This affirmation is contained in the same document, that's in their reply on page 41, and they claim that the applicant's case is a matter of diplomatic protection which requires exhaustion of local remedies. Just perhaps to criticize, Rwanda claims that the application it falls within this last category because it is a clear case of diplomatic protection. Page 30, paragraph 89. So you notice that it is not very clear what Rwanda is trying to say here. Honorable Vice President, honorable judges, I would now like to demonstrate something which is really troubling to us. And when you follow the submission of my colleague, therefore candidate this morning, you will notice that as a matter of fact, Rwanda has an abstract reasoning in their presentation of facts because of the excessive nature of their position. And this leads me to ask, is it, are we before the International Court of Justice, or are we before an autonomous African court which wants to deal with matters relating to human rights? Why? Because from a general perspective, Rwanda often adopts a strategy which consists in focusing on international law. In particular, the one, just like in the International Court of Justice, for in this case, as you are all aware, one of the dominant aspects from the structural perspective is the fact that they try to adhere to structural positivism, and they come up with issues where we have aspects of human rights which are not properly respected. So they indeed try to refer to values which are not really concerned with this case. By way of example, all the demonstration on material jurisdiction of this court is a mechanical transposition of what is happening before the International Court of Justice. The jurisprudence which has been mobilized by Rwanda is taken from the International Court of Justice. So the doctrine which Rwanda is presenting here today is also taken from the theory of general international law of the International Court of Justice. You can see in their preliminary objections, page 5, page 14, paragraph 6 and 7, etc., etc. So we don't really need to go into these references which they draw from the International Court of Justice. You can see from page 13, footnote 14, the different their doctrine is taken from the International Court of Justice, and this is quite noticeable even at the level of its reply. Rwanda does not refer to any jurisprudence of the African Court on Human and People's Rights. Page 10 to page 23 in their preliminary objections, whereas Congo invited Rwanda to reply to its preliminary objections. That said, the perverse nature of the inconsiderate extension of their of what they claim from the International Court of Justice are indeed various. For instance, they try to forget about the victims of human rights, and they try to forget about their prime nature, the prime nature of the and mission of the court, which is to ensure the protection of human rights and provide reparations where necessary. Furthermore, there's the fact that they fail to look at the priorities which should have been given to the different standards of law. They do not pay attention to your role as judges and to find out exactly what your jurisdiction is about. So they fail to look at the relationship between interstate conflicts, and they try to look for all what could constitute obstacles instead of adopting appropriate reasons to present. Thirdly, Rwanda de facto tries to reduce the impact of human rights from an imaginary perspective. In this regard, we would want to look at the constant jurisdiction of the African Court, which is quite evolutive, and it is quite logical. So, Rwanda, therefore, tries to dismantle the evolutive potential of this court, which is guaranteed under the African Charter on Human and People's Rights in the field of human rights. Fourthly, they talk about exhaustion of regional and local remedies, and their objective is to weaken a credible mechanism which is in charge of the promotion and protection of human rights. This brings me to my last point, my penultimate point, the last but one, that is the attitude of Rwanda towards the African Commission on Human and People's Rights. Honorable Vice President, honorable judges, this concerns a moral or international a moral position. They try to look at an attitude, a moral lack of moral attitude here, and they do not really pay attention to what they are saying. Rwanda, based on the circumstances, is doing all of this through a dilatory approach to confuse the judgment. They want to lead your court and the African Commission on Human and People's Rights. They do not even succeed in saying that the establishment of this court through the preamble is aimed at complementing the mission of the African Commission on Human and People's Rights. There are several judgments which have been rendered by your court and which are in tandem with the recommendations of the commission. The attitude of Rwanda towards the commission is strange and indeed unpleasant. It can be summarized in in a manner where they try to do things in their favor. Very clearly, at times, Rwanda will talk about the achievements of the commission, and where the decisions do not please Rwanda, it will say the contrary. This is the case on page 17 in its submission on preliminary objections, where it talks about the decision of the Congo in application 270, where the two parties were called upon to work with Rwanda. Now you try to look at the position of Rwanda in this situation. So we notice that there are arbitrary and strategic decisions which Rwanda will try to take to its advantage. Rwanda, in its dealing with the commission, deals only when it is in its favor. For instance, with regard to admissibility, it is important to note that the demonstration relating to exertion of local remedies could be a reference to this. In paragraph 68, I have based this on the jurisprudence of the commission, but Rwanda does not agree with the jurisprudence of the commission in paragraph 80, for instance, because it's not in favor of Rwanda. So we notice as follows: the commission declared that it has to rely on the rules relating to exhaustion of local remedies, but Rwanda does not agree with this and refer to this case of in paragraph 82, just like a magic one. This is the title: the decision of the commission on the exhaustion of local remedies in communication 237, and they claim that this is not binding and cannot be accepted. So you notice that Rwanda changes its language in its submission based on what is in its favor and what is not in its favor. This can be seen in paragraph 6274, when they try to mobilize the jurisprudence of the commission and claim that it is it's not in tandem with the constitutive act of the African Union. It is true, as we indicated and as we'll demonstrate tomorrow, that this court has always referred to the decisions of the commission to buttress its arguments when it talks about inadmissibility of an application, and we cannot therefore set aside the jurisprudence of this court. Honorable Vice President, honorable judges, I am coming now to my fifth and last point, and I'm trying to look at probity and intellectual honesty in communication and the presentation which we have before you here today. There are principles to all ethics which cannot be set aside when we want to talk about the validity of all presentations in the adversarial debates before you. So our protagonists try to discredit all these claims. When we look at the Rwandan claim and their point of view, which is indeed based on bad faith, we notice that it is translated by phenomena and other cases which are not based on facts. I am using neologism, but I must say that they try to denature a fact through selection. So they select, denature, and try to bring it to their favor. Then another part of it is to cut some of these facts and give only parts of the facts which are in favor. For instance, they take some legal documents, cite them, but do not give any details, and they try to give a different meaning to all these documents which they are referring to. An author said that this could be done by ignorance or deliberately, but with the case of Rwanda, there are levels of its presentations. One, they refer to the jurisprudence of the International Court of Justice, the European Court of Human Rights, and the African Commission on Human and People's Rights. This is normal, but it is a manner in which they do it that shocks any intellectual. At times, Rwanda would apply the jurisprudence out of its context, or they may just pick excerpts which indeed ally with their ideas, and at times some of those texts may not even exist, and they try to relate it to the intrinsic value of the case which they are trying to present. On the other hand, Rwanda is also instrumentalizing text. They attempt to use it against your court in order to buttress their case. Given the fact that time is not on our side, let's note that to look at the plausibility of their statements, the only technique will consist in carrying out a careful reading of the different jurisprudence which Rwanda has referred to. In particular, each of the paragraphs where specific comments are made, or even the footnotes, and each time we should put them in their right context to bring out a coherent meaning. Without doubt, honorable judges, it may be fastidious for us to do this, but we have done so, and the results are overwhelming. By way of illustration, one example, Rwanda took the content of paragraph 150 of the International Court of Justice between Equatorial Guinea and France in its submission under preliminary objections, while in paragraph 149 of its document, where it makes its claim on abusive remedy. Now here it is deliberate. They took a passage which goes against what they are claiming, and it is this passage which the court reminds us that in this case they will consider Equatorial Guinea, which has a valid basis, where its case was rejected. So there's a need for clear evidence in any case which is presented here. So what is stated here is the contrary of what Rwanda is claiming. Rwanda also referred to another case against Russia and other cases. Honorable Vice President, honorable judges, the second part of our presentation, of our submission, will give details of the different aspects which I've referred to in this introductory submission, and I would like to thank you for your kind attention, and kindly give the floor to Professor Kulamba, who will come to express the facts in this case.
President, honorable judges, I thank you for giving me the floor. About over 25 years ago, the last century, at least its last decade, I had the opportunity of being part of the team that came to make a submission against 3 of our neighbors, more specifically, including Rwanda, before the African Commission on Human and People's Rights. Subsequently, Minister of Human Rights, I followed up the procedure at the Commission till its conclusion, where a decision was rendered that has become a jurisprudence today. Today, I have the honor, after about 30 years, to come back to your court, the highest instance of promotion and protection of human rights in Africa. The observations are painful. There have been no progress over the years. Human rights violations have been exacerbated, diversified with barbarism. Rwanda is stepping over all provisions on human rights for women and the child, and more specifically, DRC accuses Rwanda of, through the feds and the inhuman acts that they have committed on Rwanda territories, allowing itself to do anything it wished. It committed several serious and massive violations of human rights protected by the African Charter on Human and People's Rights and other instruments ratified by the 2 states, while advancing the same pretext, repetitive narrative, arrogance against international and African opinion, an absence of accountability, and with a guaranteed impunity. It is rightly that the African Charter on Human and People's Rights thought it proper to conventionalize the right of people to peace, which is royally disregarded by RDF. The flagrant violation of these rights have been translated into a real aggression and territorial occupation of the DRC, led to a bellicose fury in the human rights space, where the rights to peace and dignity of life are guaranteed. The Vice President has said that this is the first of human rights, the right to moral integrity, the prevention of degrading treatment, peace and personal security, the right to education, the right to property, the right to housing, the right to enjoy a better state of physical and mental health, the right to the protection of family, women, the child, and senior citizens, the right to food, which is disregarded in the Goma town where the refugees are displaced, the right to development, the right to environment, the right to effective recourse to justice for reparation, the right to sovereignty. In fact, and looking closely, all these gratuitous violation of human rights, of the rights of Congolese, are part and parcel of a genocidal plan, properly thought out, well structured, surreptitiously and maliciously covered by security pretexts. Violations are also grounded on a policy of predation and on the resources of the Democratic Republic of Congo. At this stage, we have to talk about the preliminary objections, but the violation of human rights needs to be contextualized, and I'll do that in 4 dimensions. Honorable Vice President, honorable judges, it is a notorious fact that a great number of Rwandan Defense Forces from the Special Forces have invaded the eastern part of the Democratic Republic of Congo since 2021 and have been operating there, sometimes on their own, sometimes in support of terrorist armed groups. The facts that underpin this situation is armed conflict opposing the armed forces of Rwanda and the terrorists of M23, supported in weapons on one hand by Rwanda, to the armed forces of Democratic Republic of Congo, supported by volunteers of defense of the fatherland. This armed conflict was intensified in a dramatic manner, such that it has affected 2 provinces in the eastern part of DRC, North Kivu and South Kivu, affected in various places, and many territories have been impacted by Rwanda and M23. The list is very long. Unagana, Jomba, Usuru, Chuanja, Rumangabu, Kisigari, Rugari, Nyumba, Nyiragongo, Kayabayonga, Kishishe, Kichanga, Kididi, Masitani, Kanambi, Nyabibwe, and currently the very town of Goma. According to the UN report 25th December 2024, Rwanda has at least 3,000 to 4,000 troops on the Rwandan, the Congolese territory. The number has significantly increased so as to facilitate the invasion and takeover of Goma on 26 January 2025. And many reports, official reports from of UN experts and other international organizations, Human Rights Watch, International Red Cross, and so on and so forth. And they have the evidence, and among the documented evidence, the report brings other evidence, including photographic and documentary evidence and aerial images of military operations conducted by soldiers in RDF military uniform in the Nyagongo territories in between November 2022 and March 2023. There were military intelligence officers captured, soldiers captured. The evidence, we have multiple evidence, and at the appropriate time we'll have the opportunity to serve it. More recently, in a report distributed in June 2024, and the FAIR group re-emphasizes the same facts and gives evidence of the presence of Rwandan forces, particularly the special forces on the Congolese territory, and who have conquered many localities. As you do know, the Security Council reiterated the condemnation of the military invasion of DRC by the RDF and in support of M23. It's in this context that Rwanda has carried out many acts that constitute violation of human rights, for which reason the DRC has come before this court. These are facts of extreme gravity, denounces limitless barbarism total disregard for the humanity, humanity with genocide intentions for an ethnic cleansing intended or targeted again identifiable and ethnic groups. We observe that the Rwandan Defense Forces continue their acts in Congo.
Increase your voice.
DRC drew attention of the court to the fact that the ongoing armed conflict is a cause of a serious humanitarian gravity with deplorable consequences and injustice suffering for the population living there. More than 2.4 million internally displaced persons for only the North Kivu province, and to this must be added the 300,000 displaced persons in the outskirts of the Goma city. The internally displaced persons are subject to inhuman living conditions and slow programmed death. The the propagation of HIV/AIDS and diseases having affected the displaced person of the Kanyarushunga and Mungunga displaced persons made mainly of Hutus and Undis, without forgetting the victims of indiscriminating bombardment. I cannot overlook the number of rape cases carried out through in locations taken over by Rwanda and M23. Children enrolled forcefully, the looting of resources, destruction of infrastructure, of interests such as hospitals, schools, electrical generating facilities, and cultural facilities. There are many reports, and these have already been communicated as annexes to our pleadings. So I'll move on to the third point, the reasoning. The main reason of the intervention of the RDF on Congolese territory is ethnic cleansing of a certain group, the Hutu, particularly the Hutus, the Undes, as well as the Congolese population. This looting of natural resources, which is purely genocidal act. The genocidal ideology is visible but maliciously covered. The Rwandan authorities regularly use disparaging terms in reference to the Congolese population, particularly certain target ethnic groups, so as to ensure their extermination or diminution. In Kinyarwanda, they refer to them as follows. They refer to them with the term Ibichuchu, meaning idiot, a less intelligent person. It is also the looting of resources, because if you look at the cartography, the mapping of conquests on the mapping of natural resources of the Congolese territory, you see that both these maps coincide. And that is the case, for example, of Rubaya. You know that at Rubaya, M23 draws a profit of $800,000 per month, enabling them to support the war efforts and to continue their conquests with the support of the Rwandan armed forces, as well as the minerals. The new roads are being built. Finally, Honorable President, honorable judges, it is urgent to do the needful to correct the situation before it gets too late. Looking at the ongoing events on the DRC territory, you yourselves have followed what happened during the bloody takeover of the Goma town, 26-27 January 2025. 294 wounded persons. We are today at 3,000. Summary executions. Human rights defenders chased out. Many corpses decomposing across the town, threatening epidemics, rape cases, including children, forcibly displaced persons. More than 700,000 are displaced. Rwanda has announced on 29 January 2023 that it will continue its territorial conquests to the town of Bukavu, and we should expect the very worst. Honorable Vice President, honorable judges, DRC would like to appeal to you to safeguard the values of Lubuntu through your sacred duty, your sacred mission, noble mission of guardians of human and people's rights in Africa. Your vision intends to disseminate values of human rights across Africa. Through Africa, that also means in interstate relations. DRC is of the view that the time has come for the court to use its jurisdiction to bring Rwanda to reason and respect of law, scrupulous respect of human rights, not only for Rwanda, but also for neighboring countries. Honorable Vice President, honorable judges, your mission is a noble one. And Congo, coming here before you for the second time, has a lot of confidence in you, and eyes of citizens of DRC, men, women, children, widows, are looking at you. Thank you.
President, honorable judges, it is an honor for me to stand before you today, and I would like to prove the material jurisdiction of this court. To that end, I'll be speaking to 4 issues. 1, and to begin, it is undeniable and clear that your material jurisdiction is based on the violations on human and people's rights committed by Rwanda, some which were criticized in this application. Rwanda repeats again under Article 3 You heard it this morning of the Ouagadougou Protocol. This claims that this court lacks material jurisdiction to hear the issues raised in the application. To support its reasoning, it refers to a matter between states, and that matters between states should be limited to the conflict between these states at the time of the filing of the application. The applicant, for its part, affirms that the material jurisdiction of this court is established to deal with this matter. Similarly, you have the mission to interpret and apply the African Charter on Human and People's Rights, the protocol, and any other relevant human rights instrument ratified by the states concerned. Mr. Vice President, honorable judges, the Democratic Republic of Congo filed an application before you claiming that Rwanda violated principally Article 1, 4, 5, 6, 7, 14, 17, 18, 22, 23, 24 of the African Charter on Human and People's Rights. Articles 3, 4, 10, 11, 12, 15, 18, and 19 of the Protocol to the African Charter on Human and People's Rights on the rights of women, Articles 5 and 11 of the African Charter on the rights and welfare of the child, Articles 2, 6, 7, 8, 9, 10, and 12 of the International Covenant on Civil and Political Rights, Articles 12 and 13 of the International Covenant on Social and Economic Rights. Your court, your abundance jurisprudence in this area reveals that your rational material jurisdiction is established once human rights violations which are referred to are guaranteed by the Charter or any other relevant human rights instrument. You have stated to every respondent state which has tried to go away from this, just as is the case in this matter, you've stated in very clear and significant manner. So, by way of example, let's take a few words from the judgment in the matter of Peter Joseph Chacha versus the Republic of Tanzania. In this matter, it was determined, and I quote, as long as the rights which are alleged fall under the Charter or any other relevant human rights instrument ratified by the state concerned, this court will exercise its jurisdiction in the matter. End of quotation. Many separate opinions and individual opinions have gone along the same lines, and that is the case of Judge Blaise Chikaya in the matter of Uchechura versus Tanzania, where it stated, and I quote, the court has invariably considered, as a matter of fact, that where for it to have jurisdiction, it just suffices that the right whose allegation is referred to is under the Charter and ratified by the state concerned. As you must have seen through the submissions of the other party before this afternoon, Rwanda does not challenge the fact that human rights which are alleged by the DRC are protected under the Charter and other relevant human rights instruments which have been referred to in the application. This said, we believe that continue to discuss on this issue, and which is poorly used by Rwanda, can only embarrass and waste time on instead of talking about issues of human rights. Mr. Vice President, honorable judges, secondly, Rwanda's strategy, which consists in hiding behind the reality, it even made reference to the Vienna Convention on the Rule of Treaties without being able to draw the consequences of this decision. In other words, instead of Going to the systemic interpretation of this article, Rwanda prefers to limit itself to a shortcut through a literary approach, trying to stay away from the truth and the intrinsic nature of this article of the protocol. As a matter of fact, Article 31 of the Vienna Convention on Treaties, referred to by Rwanda in its defense, is very much in favor of the systemic approach. This method of interpretation guarantees that the provisions of the protocol do not produce effects in an isolated manner. They have to be interpreted and applied in a body of legal systems in force at the time when the interpretation is taking place. This approach, through Article 31 of the Geneva Convention, referred to, that in this case, it should be an intrinsic fact which is inherent in this article, but we should look for other possible cases, and we should not limit ourselves to this case. If Rwanda invites you to carry out a systematic approach of the protocol, it is simply because it is the most appropriate way of determining the meaning and the rational meaning of your jurisdiction. Rwanda claims that the text of Article 3 is clear, and it concludes that it's waste of time to seek any other meaning outside its narrow understanding of this Article 3. The DRC would like to call on the court not to follow Rwanda in its reasoning, because the clearness of a text or a notion cannot be absolutely ensured if it is not defined and limited voluntarily by the context in which it is being interpreted. Now, the term affair is different. It is not defined by the protocol. It is constructive jurisprudence which made it possible to come up with the meaning, the full meaning of this word affair. And this is renewed from time to time by your court based on the situation in which the court finds itself, on a case-by-case basis, just as it is in this present case. Mr. Vice President, honorable judges, thirdly, I would like to say that the meaning and the scope of difference brought by Rwanda should not prevent this court from declaring that it has jurisdiction. Rwanda conditions the material jurisdiction of this court to the existence of a conflict which it deems necessary, as we followed this morning, basing its position on Article 3(1) of the protocol. But the problem is that the understanding which they make of this term is different, and in several cases it is not really correct. It is artificially taken from a formalist approach, and which is abstract from the law to the extent, and as is the case in the International Court of Justice, a prior condition for the establishment of the jurisdiction of this court. Rwanda, by doing so, is trying to create confusion and lead the court to ignore the specificity of each international court, as well as the rules of procedure which it follows. Honorable judges, this court is a specialized court, and its specific mandate is to promote and protect human and people's rights in Africa. As I just stated, the protocol establishing the court uses the term affair in a different way. Now, when it comes to a concept under international law, there's the need to mobilize other mechanisms, notably the jurisprudence, including that of this court, to bring out the meaning. By doing so, we'll be become aware of the fact that the semantic nature to cover different terms could be enlarged and could be pluralistic. For instance, the Convention for the Settlement of Conflicts at The Hague on the 18th of October in 1907, they used meanings from Articles 1, 2, and 9, and I was saying that they use expressions differently. Conflict, dispute, etc., etc., without necessarily giving them specific meanings. Accordingly, from this principle, the applicant rightly believes that Article 3.1 of the protocol should not be interpreted in an isolated manner from a narrow perspective. It should be looked at from the general perspective of the protocol establishing the court, whose adoption is not mimetic in nature. This provision should, as a matter of fact, be understood in combination with the preamble of the protocol and other relevant provisions. That is why we stand for the fact that a systemic approach will be the most appropriate approach in this case. Furthermore, the process of establishment of the court shows the relative nature of the thesis which existed and how we try to see how justice could be conciliated in Africa to come up with an acceptance of different concepts when they are presented before the International Court of Justice. The context of the adoption of the protocol was that of the promotion of the defense of human rights, characterized by the strengthening of the protection of these human rights in Africa. It was dominated by issues of sovereignty of different states and states which did not require any interference in their affairs, in the face of the imperative, the requirement of the protection of human rights in Africa. And that is indeed the issue in this matter. In any case, it appears clearly that it is as a result of total deception that the opposite party is coming up with different concepts. Rwanda would want to give the impression that the term conjunction is used to bring two terms together, and that to them will mean that two concepts cannot be changed. They cannot be synonyms. Consequently, the equivalence in meaning between two terms, and I quote, the fundamental rule in the treatment of treaties, according to which a treaty should not be interpreted to make some parts of the text redundant or void of meaning. So, and I will want to open the inverted commas once more. Rwanda will want to use this principle, and it is contained in paragraph 30 of its response. It would appear, as a matter of fact, that there's sophism, because Rwanda simply forgets that the first principle of interpretation under Article 31.1 of the Vienna Convention on the Law of Treaties begins with the ordinary remedy which could be found. And in light of the objectives of the case, in other words, any attempt of a remedy 31.4 of any convention which has a particular sense, a particular meaning, will be exceptional. So, a term will be considered to be particular if it is established that that is the intention of the parties which use the said term. But it is difficult to administer evidence of such meaning in the interpretation of Article 3.1 of the protocol, which governs this court. Rwanda will continue to persist following this approach, and that is why With such a demonstration, it preferred to assimilate the situation between the African Court on Human and People's Rights and the International Court of Justice. Let us try to imagine that the approach which govern practice in these courts cannot be exactly the same in both institutions, because they lack legal basis. Rwanda's argument should simply be dismissed in block. The respondent insists on the conjunction a, that's an in French, to give this word a meaning which is not accepted in this case by referring to this conjunction a, which means an in English. Rwanda gives the impression that it does not know that in the same provision of Article 3(1) of the protocol, the conjunction a or an has been used 4 times in this same article. The fact is, from the syntagmatic point of view, without being redundant or lack of meaning, the several use of this conjunction an or a plays the role of a coordinating conjunction. It does not express in the proper sense a simple addition when we say an, but the first enumeration of the conjunction and between matters and conflicts which are from the same level of syntax coordinate and unify 2 terms whose semantic meaning cannot be distinguished. It would have been the same if the article used a comma before the word and if it had been written in this manner, I quote, "The court has jurisdiction to hear all cases, comma, and all matters or conflicts." The meaning would not have been very different. If the court wanted to make a semantic difference, it would have put a comma before the word and, but that's not the case here. And it would have been different also if we found repetition of the conjunction and to show a difference between the terms which have been enumerated. There, in a similar case, therefore, we could say that there's a difference in meaning between the 2 terms, notably if the provision was stated as follows, and I quote once again, "The court has jurisdiction to hear and all the cases, comma, and all the conflicts," end of quote. The and in this case would have had the status of an additional conjunction which would have given specific meaning for each term enumerated. But unfortunately, this is not the case. In any case, the shortness of Rwandan reason emerges when we come to the other uses of the same conjunction and, which is used after the same provision under Article 3(1). So we become aware, for instance, the second use of and, which exists between the terms interpretation and application, plays the cumulative role of the fact that these 2 terms fall under the purview of a reasoning where they are linked, and we can even say they are integrated. So the mission of this court does not only consist in interpreting, but also in applying. To apply an instrument, you should first of all have the meaning within the purview of a human rights case. Before this court, the application which they do of the charter, the protocol, and other relevant human rights instruments is as a result of interpretation. The third level of meaning of conjunction, of the conjunction and, in the provision of Article 3(1) is preceded by a comma. And here, the conjunction and comes after the enumeration of the charter and the protocol. And here, there's an additional conjunction which is different from the first enumeration of the expression different and case, or matter and case. The third conjunction and plays the role of biconditionality because it is required to express a condition which is necessary and sufficient. In other terms, it does not suffice for any other relevant human rights instrument to exist. There's also the condition of being ratified by the states concerned for this court to have jurisdiction to interpret and apply it. This means that the court will have jurisdiction if and only if all other relevant human rights instruments have been ratified by the states concerned. In all, following every logic, the DRC considers that every good interpretation cannot admit that the term différent and affair before this court should be used indistinctively to refer to the word conflict, an ordinary conflict between two parties before the court, where one is an individual or a state alleges the violation of human rights claimed to have been committed by the other or a state, where the first holds the second as being responsible. The jurisprudence of this court is indeed a reference which we cannot set aside, and it is a testimony of the fact that the court alternatively uses the term différent or the term affair for individual cases, just as it does for interstate cases. Significantly, therefore, it should be noted that it is not by chance that this court, in its order of 7th March 2024, rendered in this case referred only to the word affair, and Rwanda cannot claim that the judges of this court did not know that this conflict was between two states. So if the term différent had a particular meaning in the system of the court in interstate contentious matters, why did the court prevent itself from using that word? And even more, if the court preferred to use the word affair with regard to the instant case in its ruling, whereas it had the two concepts before it, by virtue of which, so why should Rwanda substitute the word affair and the word différent, whereas they are all referring to cases? This becomes even more legitimate when we consider the fact that even in the hypothesis of individual cases, the court follows the same logic. The proof is that the matter Subi Gore and others versus the Republic of Cote d'Ivoire is indeed an excellent example. In this matter, the court explicitly stated, and I quote, that the protocol does not make any distinction between cases or matters that are tabled before the court, as long as this conflict concerns the application and interpretation of all the instruments under Article 3 of the protocol, end of quote. Honorable judges, it is important to note that the court even goes further in the explanation of the meaning of words. In fact, it uses, in the place of the coordinating the conjunction, and it uses another coordinating conjunction where in its cases, and this is not by accident. So they seem to be an equivalent in use, and they could be alternatives. And this means that the concepts affair and différent are identical. They refer to cases or matters or conflicts, and therefore they can be used indistinctively in an individual case, such as in interstate cases. To that end, this court will simply dismiss the argument of Rwanda in challenging its material jurisdiction. Mr. Vice President, honorable judges, fourthly, I want to say that in bid as it made. The evidence of differences between Rwanda and the DRC are many. Rwanda would like to pretend that even if we consider the hypothesis that the court should consider that the existence of a difference or a conflict could affect its jurisprudence, the DRC of the position that there are lots of differences between Rwanda and DRC. Let me use this opportunity to say that the existence of a conflict between Rwanda and DRC are many, and Rwanda comes up with the illusion on this aspect. The DRC has presented through its submissions several points which establish unequivocally conflicts which exist between the two parties at the time when this court was seized of the application, and it was contained in the submissions, and the submissions which have been given before you have demonstrated the continuous nature of these flagrant violations of human rights which Rwanda is trying to challenge, at times implicitly, at times explicitly. The last episode has just taken place last week in Geneva in the Human Rights Council of the United Nations, which under point 1.3 of its resolution condemns very strongly all the human rights violations, strongly condemns the military and logistics support of the Rwandan Defense Forces to the M23 Defense Forces, calls on Rwandan forces to bring to an end their violations of human rights. End of quotation. Honorable judges, when a resolution like this of the Human Rights Council uses terms such as condemns very strongly, calls on, it is not optional. And in any case, from the point of view of the DRC and Rwanda, on the violation of human rights, where the first holds the second, has been responsible and expressed in several ways and on several occasions, they are manifestly opposed. By way of illustration, would like to state the following facts. One, the Rwanda is playing the role of the ostrich. The DRC is blaming Rwanda of attacking its territory by using M3, which carries out several violations of human rights. That's a strategy which it has carried out for several years by fabricating these two rebellious forces which it controls, CNDP, M23, etc. For its part, Rwanda denies categorically by claiming that the conflict between the M23 and the government of Congo is a domestic problem, and that Rwanda should not be taken as a scapegoat or be assimilated to M23. However, while Kigali blames Kinshasa of cohabitating a group which was in charge of the case in Rwanda, on the 14th of 2022, a UN representative wrote to the Security Council where a letter of the Minister of Foreign Affairs of DRC was annexed, and it stated clearly that there were accusations of human rights violations committed on the 10th of June 2022 at 2:15 by Rwandan forces in Giruma and Kabaya, situated in the Kisigari region in Buisha in Rutu region. On that day, scores of bombs were fired through long-range cannons from Rwanda, and it led to human and material destruction. The destruction of a school, Institut Saint-Gilbert, the death of 2 children, Shaka Mapenzi and Jeremy Evumbiza, and they were both 7 and 6 years old. The Congolese minister would like to recall that 2 soldiers of the Rwandan Defense Forces were captured on the 28th of May 2022 by the Congolese Defense Forces with the support of the local population. On that occasion, the Congolese government called on the council to deal with this letter, calling on it to circulate it as an official document of the Security Council. As in reaction, Rwanda dismissed categorically all the accusations made by the DRC on the bombings on its territory. And with regard to its soldiers who were captured, the government of Kigali stated that the 2 soldiers of the Rwandan Defense Forces were kidnapped on the 28th of May 2022 by a joint force, FADC and FDL, whereas these soldiers were patrolling the borders between the DRC and Rwanda. Thirdly, and just by indication, during the meeting of the Security Council on the 9th of December 2022, the Congolese Minister of Foreign Affairs clearly underscored the responsibility of Rwanda in the massacre of Congolese population on the 28th and 29th of November 2022 at Kishishe and Bambo in Hutu territory. Mr. Vice President, honorable judges, the tragedy of that day, which should be called the Kishishe genocide, was indeed particularly cruel because it was planned and it led to the systematic massacre of the population. And if we look at this situation, even people who were sick in hospital were killed. People were hiding in schools and in churches were killed. Rwanda expressed, in accordance with its traditional rhetoric, a categorical denial of these accusations. In a communiqué published on the 22nd of December 2022, they protested in these words, I quote, "Trying to deal with complex situations by repeating and applying false accusations of the government of the DRC cannot lead to a sustainable solution. Notably, the mediatization of the massacres of Kishishe, which is fabricated by the government of the DRC, which it attributed to M23, and without any investigations, this spread far and wide. Whereas there are indications that, on the contrary, there was confrontation between the M23 and illegal armed groups related to FDC. End of quote. Mr. Vice President, honorable judges, it emerges from all what follows and the affirmations contained in the submission of the DRC that Rwanda was aware of these allegations of the applicant and reacted by protesting against some of the accusations. At times, Rwanda relies on eloquent silence, and when it is blamed for carrying out genocide on Congolese territory. For all these reasons, the applicant praised this court to dismiss the claims of the respondent state and to declare that it has material jurisdiction. While I would like to thank you all for your attention, I'd like to pray you, Mr. Vice President, and the court to give the floor to Barrister Marcel Muchunga to talk about territorial jurisdiction. I would like to thank you.
Vice President, honorable judges, it is a real honor for my modest person to take the floor within the framework of this procedure. I am speaking in my turn, following my esteemed colleague, Mr. Jean-Paul Siguri, to complement the pleadings and submission of the DRC on this aspect of jurisdiction, especially the territorial jurisdiction of the African Court of Human and People's Rights. We have to underline from start that the point is not to address the issue of extraterritorial jurisdiction, of national jurisdiction of the respondent state. As a reminder, the territorial jurisdiction before such a court is understood according to the venue the dispute occurs. In this situation, the question to which we have to answer consists in clarifying whether the court has the capacity to decide on the violation of human rights alleged by the applicant, by the respondent state, while they have not been committed on the Rwandan territory, but rather on the Congolese territory. The answer to such an interrogation that is very important given this situation is facing two contradictory theses or assumptions. The first assumption is supported by the applicant state. The point is to answer by yes, starting on the fact that the violation of human rights were committed on the territory of a state party to the protocol establishing this court. On the other hand, the second assumption defended by Rwanda suggests that the court is not competent insofar as that the alleged violations are not committed on its territory. As a reminder, the scope of this court is determined or defined in Article 3 of its protocol. The latter reads as follows: the court has jurisdiction to consider all the matters and all the dispute referred to it regarding the interpretation and the application of the Charter, the Protocol, and all other relevant instruments relating to human rights and ratified by the states concerned. In case of contestation to know whether there is jurisdiction or no, the court decides. The DRC confirms that no reasonable interpretation of this provision can confine the competence of the court to the only case of human right violation committed on the respondent state territory, and this is based on 4 reasons supported by the DRC. First, the literal reading of this article or provision. Second, the relevant jurisprudence of this court on this very issue. And 3, the jurisprudence of the Commission of Human and People's Rights on this issue. And 4th, the principle of the usefulness of the interpretation of the preamble. Honorable Vice President, honorable judges, the very broad formulation of Article 3 suggests an extension of competence of jurisdiction of the court beyond the territory of the respondent state where violation of human rights occur. From the reading of Article 3 of the protocol, it appears that the author did not deem necessary to limit the territorial meaning or to the territory. On the opposite, it tried to divert from the authors of the ICG and the International Pact on Civil and Political Rights that were animated by the manifest will to limit the territorial competence of the European Court of Human Rights and the Committee of Human Rights to the territory of the respondent state. This stems from Article 1 of the Convention, the Safeguards Convention of Human Rights and Fundamental Freedom, according to which all the contracting parties recognize to all persons under this revelation recognize the rights defined under this convention. Similarly, it is the same for Article 2, Para 1 of the International Covenant on Civil and Political Rights that provides that the state parties to this covenant commits undertakes to respect and guarantee to all individuals on their territory and relating to their jurisdiction the rights recognized under this covenant. What we can say here is that the fact that the protocol have not limited the territorial competence to the jurisdiction like the European Convention or to the territory and the jurisdiction, like the International Covenant on Civil and Political Rights of the state party, is not done by chance. It shows the willingness to assume a broad competence of the court that has established it. This position, defended by the DRC and supported by the doctrine in the field, shows the point of view defended by an author regarding the African system on human rights, who is very well known, Judge Kibambai. And this is what he says, and I quote: "The violation incriminated, has it to be committed in the territory of one of state party so that the commission becomes competent? It doesn't exist in the charter an equivalent of Article 1 of the European Convention, according which these states guarantee the right of the persons under their jurisdiction. But since there is no limitation regarding the obligation of the state parties to the charter to protect the rights that it recognizes, we have to deduct that the commission is competent even if the violation imputable to a state party occurs vis-à-vis a person protected beyond and outside the national territory," end of quote. It goes without saying that what is done in the commission should be applied to the court, given the complementarity between the two institutions. Similarly, Honorable Judge Blaise Chikaya notes in his individual opinion, which is appended to the ruling of the court Morna against the Republic of Ghana and others, the following: we have to recall the terms of Article 3 that do not exclude any matter from the jurisdiction of the court as long as it is seized regarding the interpretation and the implementation of this charter or any instrument ratified by the state which is pending in terms of human rights. And he says, it is the court that should decide on it. So it is wrongly that Rwanda affirms in its preliminary submission that given the absence of a similar terminology, similar to the one found in the International Covenant on Civil and Political Rights or the European Convention on Human Rights, the court is right to limit its territorial jurisdiction to the facts committed in the territory of the responding state. This affirmation does not come from a wrong comprehension of Article 3 of the protocol, but also and above all from the jurisprudence of the court, which is in favor of a territorial jurisdiction which is wider. The second argument of the DRC, as we said it, is that the lessons drawn from the jurisdiction of the court itself lead to the competence beyond the national territory of the responding state. This court has always retained the status of state party to the protocol and to the charter as a principle to determine its jurisdiction. So the jurisdiction is either explicit. It is the case when the assumption is to consider this issue in a given angle, or implicit when cases where the question was not similar to this case. The territorial jurisdiction of this court is confirmed in a recent ruling that deserves to be evoked within the framework of this matter. So the court has explicitly affirmed its jurisdiction through two judgments, at least, where the circumstances were calling for a very accurate response on the territorial competence on facts done and beyond the respondent state. In the case of Yakuba Traore versus Mali, the court deemed that its territorial jurisdiction, it underlines that the alleged violation occurred on a territory of a member state of the African Union. It has, therefore, territorial jurisdiction. This position goes within the framework of its similar motivation as appearing in the judgment of March 2016 in the matter Mogandi and 9 others, where the court has deemed that regarding its competence, it deems that given the fact that the alleged violation occurred on a territory of the African Union state, where the state parties are members, so it has jurisdiction to examine this matter. So Rwanda did not mention this jurisprudence, but maybe with some more judgment, we could see clearly that in these 2 examples, the court has admitted and widened territorial jurisdiction. Indeed, the relevant criteria to declare itself competent needs the fact that the violation were happening in a territory of the African Union, that is to say a state party of the Charter and the protocol establishing this court. It is not by chance, but the interpretation of Article 3 of the protocol is in conformity both to the general nature of its formulation and the will of its author. The other judgments of the court on the territorial jurisdiction cannot be interpreted only on the light of these 2 judgments. In order to establish a territorial jurisdiction, the court bases itself on the Court on Human Rights, that is to say, 1 state party, the respondent state, 1 state party who is the applicant. So the respondent state is party to the Charter, and the state party, or the respondent party. So when we use the term namely, it means that, in other words, among other things, in particular, including, so when the court talks about state party, that is to say respondent state, it means the state party, namely, for example, or among others, the respondent state. Regarding the word namely, it means in this case, in this very case, when the court says the state party, that is to say the respondent state, it means state party. Within this case, the respondent state. So in all the jurisprudence, the court does not contradict itself, and it doesn't question the state party to determine its territorial competence. It only clarifies that within this case, in this case, the state concerned is the respondent state. In short, the Rwanda should not always echo the jurisprudence of the court in a selective way, in a hastily way. On the contrary, the reading of this jurisprudence showed that the state party to the protocol and the charter constitute the criteria to determine the territorial competence of the court. The condition to extend the territorial competence through a specific judgment of the court. In a very precise and accurate judgment in the matter Bernard Mora versus Republic of Ghana and others, the court notes the following, and I quote, contrary to the text applicable to the European Court of Human Rights and to the American Court of Human Rights, the Charter do not precise any resort. The protocol do not define the competence of the court, but the court has always considered and examined its territorial competence. The jurisprudence in the field of human rights has constantly extended the territorial application of treaties beyond the borders and till areas where the state have effective control and where the acts committed by their agents under their military or political influence. Consequently, we can see a consensus so that the obligation to protect or not to violate human rights go beyond the territorial limits of the territories of states. It also notes that the alleged violation of human rights occurred in the territory of the Arab Republic, which is a state party to the protocol, but beyond the national borders of the respondent states. So the court cannot declare itself competent because the alleged violations were committed in a state party to the protocol. To exercise its territorial competence, the court should make sure that the alleged violations were committed by a respondent state or by persons under its control. From this ruling, we can see that in order for the territorial competence to be established, we need two conditions, two preconditions. That the alleged violation be committed on the territory of a state party to a protocol, first condition, and if the violation of alleged violation have been committed by the respondent state or persons under its control. This is the second precondition. As we can see it, this ruling confirms the constant jurisprudence that its territorial competence is established as long as the alleged violation of human rights were committed on the territory of a state party to the protocol. But the court just added a condition, a practical condition, that the respondent state should be the one where the perpetration of such violation is blamed for that. And given what was said, the court is going to declare itself competent as far as Rwanda has committed and continue to commit violation of human rights on the territories of the DRC, which is a state party to the protocol. The third argument of the DRC is based on the fact that the jurisprudence of the Human and People's Rights Commission is in favor to the broadened territorial competence of the court. There is no determining condition justifying the fact of not inspiring ourselves from the Commission of Human and People's Rights as suggested by Rwanda. And this was demonstrated in the introductive pleadings of my colleague Yvon Mikashi. Indeed, this court is not the only and sole mechanism of protection of human rights who have retained the status of state parties as criteria to determine its territorial jurisdiction. It was preceded in this by the Commission, especially its decision of May 2003 relating to the communication 227/999, which opposed the DRC to Burundi, Uganda, and to the respondent state. In this matter, as in this one, the alleged violation were not committed on the territories of the respondent state territory, but rather on the applicant state territory, which did not prevent the Commission from affirming its territorial competence and jurisdiction. So Rwanda tries to weaken the DRC because saying that the Commission did not really focus on this issue. But how can we imagine that the state party to the protocol can be kept responsible only if this it is perpetrated on its territory and not on a territory of another state party? Honorable Vice President, honorable judges, it is the interpretation of Article 3 of the protocol that guides us to take into account the principle of usefulness of this provision. So any possible interpretation that will decline the territorial jurisdiction of the court because the violation of human rights were not committed on the territory of the respondent state would be a very negative precedent for human rights in Africa. This is for two reasons at least. On the one hand, this would mean that would take Rwanda as not responsible for the violation of human rights, and this would be new crimes without sanction. On the other hand, such a solution would mean that we encourage or we entice the respondent state and others to go beyond the national borders of their respective territories, to go and elsewhere and commit in full impunity violation of human rights on the land of neighboring countries, and not to feel responsible of their commitments to the human right charter. That is to say that Article 3 of the protocol would be empty from its object, scope, and meaning. That is to say, the protection of human rights in Africa, and it will be null and void. In conclusion, Mr. Vice President, Honorable Vice President, Honorable Judges, the Court will reject and dismiss the submission of the respondent state, and reaffirm its territorial jurisdiction in addition to the material jurisdiction to consider this matter. Thank you very much.
Applicant states you still have about 10 minutes to go. You still have about 10 minutes. Honorable Vice President, Honorable Judges, the Council of DRC believe they have brought they've made sufficient submissions to the court following the submissions of Rwanda. The court is adjourned for 10 minutes, 10 minutes break. now the court to put questions to the respondent state. The first question will come from Justice Dennis Dominic Ajay. The questions will go to the two parties, and then we'll take a break and give you some time to organize your answers. The questions will go first of all to the respondent state, and then to the applicant state. We break to give you a bit of time to consult for 15 minutes, after which we'll come back for you to respond. Honorable Justice Ajay, you have the floor for your question. Honorable Justice Ajay, Honorable Justice Hanukam, you have the floor for your question.
Over alleged violations of rights protected by the Charter or any other human rights instrument ratified by the respondent. However, and therein lies my question, insofar as any claim by the applicant relies solely on the provisions of the UN Charter and the Constitutive Act, which in the respondent's submission are not human rights instruments, the court does not have jurisdiction over such claim. And the question is, what is your explanation of the word solely? And do you think that the applicant is relying solely on the provisions of the UN Charter, the Constitutive Act, as you have so claimed? Thank you.
Merci, honorable Anoukam Stella. Honorable juge Shafika Ben Salah, vous avez la parole pour vos questions à l'état défendeur.
Merci, Monsieur le Président. Je vais essayer d'aller doucement, comme ça la traduction va suivre. Vous liez la compétence matérielle à l'existence du différent. Pour vous, il y a une connexion entre les deux termes. La question que je pose, est-ce que votre problème, c'est dans l'existence de ce différent, ou alors c'est que pendant le dépôt de la requête, ce différent n'existait pas? Parce que vous avez insisté sur l'existence du différent et le dépôt de la requête pendant l'existence, au moment de l'existence de ce différent. Donc, c'est la question que je pose. Parce que moi, quand je reviens au document, le requérant, il prouve, entre guillemets, c'est-à-dire pour lui, c'est des preuves qu'il présente, pour justement justifier ce différent. Il parle par exemple, dans le cas de l'Union africaine, il y a beaucoup de choses qui se sont passées et qui prouvent qu'il y a un différend qui a été exposé devant une certaine assemblée. Dans le cadre du processus de l'ANDA, la même chose, il y a certains faits qui ont été exposés et il y a eu un feedback, etc. etc. Donc tout ça est dans le document et je pense que vous avez quand même pris note de tout ça. Donc c'est ça ma question. Essayez de m'expliquer votre position. Est-ce que c'est le différent qui n'existe pas ou alors ce qui n'existait pas au moment du dépôt de la requête? Merci, Monsieur le Président.
Merci, honorable juge. Honorable juge Mengue, vous avez la parole pour vos questions. Merci.
Merci, Monsieur le Président. Ma question va dans le même sens que celle de ma collègue qui vient de me précéder. Juste pour demander, à sa suite, pour vous demander quand est-ce que vous pouvez affirmer qu'il y a un conflit ou bien qu'il existe un différend?
That there is a conflict between the parties. What is the evidence of the existence of a conflict, according to you? Thank you. Menge, Honorable Justine, Honorable Justice Benashu, have the floor. Thank you. President, you aver that the matter is a matter of peace, international peace and security. My question is, the fact that the matter is a matter of peace and international peace and security, as you claim in your submission, does that exclude the possibility of this matter having a greater dimension of human rights? Thank you. Those are the questions for the respondent state. Now, questions for the applicant state. Honorable Justice Ajay, your questions for the applicant state. Thank you.
Thank you, Honorable Judge Ajay. Honorable Judges Stella and Anukam, do you have any question for the applicant, please? Thank you, Mr. President. Honorable Judge Anukam, Honorable Judge Bensulam, over to you. Thank you, Mr. President. I would like to have some clarity regarding the applicant. Could you please, regarding to the application filed, when the facts happened, because you have mentioned several dates regarding the application submitted before us. When did these facts happen? Thank you very much, Honorable Judge Bensawa. Honorable Judge Dean, Judge Ben-Ashur, over to you. Thank you very much, Mr. President. So the applicant state an interstate matter filed before the African Court of Human Rights can it be assimilable or comparable to any matter submitted by an individual for violation of a right or several rights of human rights guaranteed by African Union treaties ratified by the states concerned? Thank you, Honorable Judge, for the question to the two parties. So now it is 3:35. We will grant you 15 minutes to allow consultation. So we are going to break for 15 minutes and come back after this period of time so that we give you time to answer to the question in conformity to the order in which the questions were asked. The session is adjourned. Resume. Please take your seats. We invite the respondent state, the Republic of Rwanda, to come and answer to the questions raised by honorable judges. Over to you. Fifteen minutes to answer.
With the question that was asked by Honorable Justice Ajay, who asked us to talk about our appreciation of territorial and extraterritorial jurisdiction, particularly taking into account the Bernard Mona against Benin case. In that case, this court was actually very clear that the starting point is always that the conduct must have occurred within the territory of the state concerned. That was the starting point in that the court pointed out in that case. However, in the Bernard Mona case, the court talked about three things that might result in a different situation. First of all, the court, and one can see this in paragraph 149 of the judgment of the court in Bernard Mona, the court talked about acts and omissions that are committed within national territory, but that generate extraterritorial effects. So these are acts within the territory of the respondent, but which has an effect outside. But that's still something that the respondent has done within its own territory. The second thing that the court talks about in that case was that there are certain specific rights, and the court was very clear in paragraph 151 of its judgment that it was speaking about the right to self-determination. Certain specific rights that are stipulated in the Charter, in which, in the view of the court, it is clear that they extend beyond national territory. And the court said that by its nature and by the manner of the right to self-determination. So it was very clear about the right to self-determination being one that also applies extraterritorially towards other people. The third thing that the court talks about in that case is it talks about developments with regard to international and regional tribunals where there has been an expansion beyond territorial jurisdiction. And there the court points to some case law of the European Court of Human Rights. However, it is important to note that actually the jurisdictional provision of this court in the protocol is not the same as the way in which the European Convention on Human Rights is expressed, and not the same as the way the International Covenant on Civil and Political Rights is expressed. The International Covenant on Civil and Political Rights explicitly says in Article 2, it talks about all individuals within its territory and subject to its jurisdiction. So it provides an additional basis to talk about extraterritorial jurisdiction within territory and subject to jurisdictions and expansion. Similarly, the European Convention on Human Rights in Article 1 also talks about everyone within their jurisdiction, and that court, the European Court, has said that use of that phrase, within their jurisdiction, allows that court to go beyond territorial jurisdiction. So that's Justice Adje's question. Honorable Lady Justice Anukam asks us about paragraph 68 of our pleadings, where we say insofar as the applicant relies solely on the provisions of the Charter and the Constitutive Act, there is no jurisdiction. And the question is, what does solely mean there? So we accept that if the applicant is relying on the African Charter, or it's relying on the protocol, or if it's relying on what is properly a human rights instrument, the court will have jurisdiction. Even if in relation to that act, it also makes mention of the UN Charter, or it also makes mention of the Constitutive Act. But there are two things I think that are important. First of all, if it only relies on the Charter or the Constitutive Act, we say there's no jurisdiction. Secondly, if it relies on the African Charter or the protocol, but also mentions the Constitutive Act of the AU or the UN Charter, this court's jurisdiction is only to find violations of those human rights instruments. So this court can't find that there's a violation of the Charter, UN Charter, or find a violation of the Constitutive Act. It will have to find a violation, if any at all, only based in the human rights instruments that are concerned. And then the question by Honorable Lady Justice Shafika, and maybe if I can take it together with the question that was posed by Honorable Lady Justice Menge, because I think the questions go to a very similar point. So the question was that we link the material jurisdiction of the court to the existence of a dispute, a différend, as stated in Article 3 of the protocol. And the question is, at what time must that dispute, the différend, had existed? And our argument is that that dispute must have existed already, it must be in existence at the time when the application was filed. It must already have existed. Now, Honorable Lady Justice Shafika says, what is our position in relation to the documents? The documents that were cited by the applicant. All these statements alleging actions by Rwanda prior to the filing of this case. And our argument is that this requirement on the existence of a dispute, it has to be a relevant dispute. It has to be a relevant dispute. Not a difference or a dispute relating to other things. It has to be a dispute that relates specifically to the human rights violation submitted. So, the documents that the applicants have submitted, they allege, before the filing of this case, aggression, they allege unlawful use of force, they allege occupation, but if you look at those documents, in none of them, at that time, did they actually allege human rights violations. They do not allege human rights violations. The only documents that they have pointed to that allege human rights violations come after this case was filed, after the application. So I think this goes to it goes to the question of Lady Justice Menge, that when are we able to assess that there was a dispute, different, between the parties? Well, all we say is that at the time when the application was filed, there was no dispute relating to human rights violations at the time. That's what we say. And if I may now move on to the question by Honorable Justice Ben-Archer. So the question says that we say that this is a matter of international peace and security, but does that exclude the possibility of a human rights dimension? I think in principle, the answer is no. In principle. Because something implicates peace and security does not automatically mean that there is no human rights dimension. But what we are arguing is that this case actually mainly concerns those political issues. They mainly concern those issues which are then couched in human rights language. And second, going back to the point that I just made, we see that from the fact that there was no dispute around human rights until this case was filed. I think I have gone through the questions posed by the honorable members of the court, and I wanted to ask whether it would be of assistance to the court for us to put some of these answers briefly in writing within a short period of time, if it would assist the court to do that.
Vous pouvez bien produire cette pièce à la cour, s'il vous plaît. Vous pouvez faire le résumé, nous faire parvenir vos éléments de réponse aussi, s'il vous plaît.
And forward it to the court. They'll be very welcome. Thank you. The applicant states you have 15 minutes to respond to the various questions put by the court. I wish to, what you promised to forward to the court, it might be useful to forward it to the applicant state as well. Honorable Vice President, Honorable Judges, I thank you once again for giving me the floor, giving me the opportunity to react to the concerns raised by the four eminent judges in the form of questions. The first one came from Honorable Justice Ajay, and if I followed correctly, he wanted me to distinguish the procedure, the relevant procedure, given the fact that there is a procedure or there's a matter before the East African court and this court. I wish to crave the indulgence of the court to respond in detail tomorrow for the following reasons. Here we are analyzing issues relating to jurisdiction, and from the issues coming from the registry, matters relating to admissibility will be tomorrow. And it's our opinion that this issue was raised by the respondent state in the portion that deals with admissibility. In a few minutes that will follow, we might say very little or maybe very little, and tomorrow will give us a better opportunity to give more information. I don't know if the court will agree with me, so that tomorrow in our submissions, we'll be able to deal with that. The second question came from Justice Anukam, and she wanted us to indicate the period during which the alleged violations took place. I'll be very brief. Beyond what has already been said in our submissions, let me read a paragraph of the report of the group of experts of June 2022, and that is paragraph 60, which confirms exactly what we said in our application, and it's as follows. M23, that is, remain inactive until beginning of November 2021, date on which it started a number of attacks against FARDC in the area where the borders, in the border area of three countries, Rwanda, DRC, Uganda, and soldier of FARDC, and stealing equipment and food, and these attacks and subsequent attacks got civilians to leave the area. We did say in our application that the date is relevant, and the date is 21 November 2021, characterized by the resumption of hostilities by M23. And when you mention M23, as we have demonstrated, it is the Rwandan forces. The report is voluminous, and I mentioned this mentioning localities with serious consequences relating to human rights, killings, rape cases, and so on and so forth. This enables me to move on to the question posed by Honorable Ben-Saula, which is similar, relating to how far back the facts go. Here, let me make a distinction to confirm what I said earlier, that these are matters that are notorious, and they go as far as November 2021. But there has been a development on the field characterized by resumption of acts that constitute violations of human rights, and also some of the alleged violations against Rwanda cover a period, and where these acts crystallized at a certain point, and we'll come back to that when we start making our submissions on merits and give a chronological set out in a chronological manner how the various acts took place. But for now, the short answer is 21 November 2021. Now, the question of Honorable Justice Benasho, let me simply say that there's no similarity in any respect between the application initiated by an individual or NGO and interstate matter. In some respects, from the material standpoint, there is identity of object, that is violation of human rights. Now, if we find ourselves dealing with an application initiated by an individual NGO or interstate application, what characterize the determination of material jurisdiction is violation of human rights. But there is a nuance when it comes to the seizure, because applications in relation to interstate matters, we do not know a declaration. It's sufficient that the state must have ratified the charter But for individual applications, we have to read Article 5.3 that refers to Article 34.1. So in that regard, there is a certain nuance, a difference, such that the two may not be the same in all regards. Honorable Vice President, I believe I have answered the concerns of the Honorable judges, and if you require further answers, I will be ready to provide them. Thank you. So, answers, and as you requested, the issue relating to the matters that will be dealt with tomorrow can be deferred to tomorrow. We now call the respondent state for its final comments for 30 minutes, final observations, following the various presentations. If you still have some observations to make, which we refer to as final observations on jurisdiction, then this is the opportunity to present them. If you have none, it's okay.
the protocol, and other relevant human rights instruments. So the argument about the use of commas or non-use of commas doesn't really take us anywhere. And then if I may come on to the question about when did a dispute arise between the parties? We already had questions from the honorable judges on this. But I just want to make one point in response to what you heard from the other side. They argue that the evidence of the existence of a dispute between the DRC and Rwanda on human rights, they said the evidence is many. And then they gave an example. They said, we see this in the last session of the Human Rights Council, which took place in Geneva in 2024. And then they argue that the United Nations Human Rights Council speaks about human rights violations. But honorable members of the court, this is exactly the point. That at the time when the application was submitted, there was no evidence of the existence of a human rights dispute. This is exactly why they are now referring to matters that occurred in late 2024, well after the application was filed. Let me turn to the arguments around territorial jurisdiction. And there, I think they made 4 points to argue that the court has territorial jurisdiction, even though these were not matters that occurred in the territory of Rwanda. The first argument that they make, they say, look at the literal reading of the provision. And then they make reference to those two treaties actually allow for matters beyond territorial jurisdiction. So they say, the applicant says, that there is no limitation of the jurisdiction of this court in Article 3. But that is not the question. The important point is that there is no expansion of territorial jurisdiction in Article 3. That is the point. There is nothing in the text of that treaty that expands the jurisdiction of this court beyond territory, unlike the other treaties that they cite. And then they refer to the jurisprudence of the Commission, and they say there is no reason not to use the jurisprudence of the Commission. Whereas we have indicated, the mandate of the Commission is not the same as the mandate of this court. As I indicated in my earlier submissions, one of the reasons why this dispute requirement exists is to give the parties the chance to have an amicable solution. The Commission can do that, even after something is filed to the Commission. This court cannot do that. So filing a submission to the Commission is not the same as filing to the court, and that is the reason not to use the jurisprudence of the Commission. The final submission of the other side on territorial jurisdiction, they said, Article 3, they said, would be emptied from its object, its scope, its meaning. It would be null, it would be void, if you require that acts must have been committed within the territory of the respondent state. All I will say is that this is extremely far-fetched. Article 3 will continue to be of significance, the same significance as it has had before this case. And as you have consistently held, the matters must fall within the within the territory of the respondent state. So those are my final observations on the question of jurisdiction today. And with your indulgence, at the end of the day tomorrow, the Honorable Attorney General will make submissions that wrap up the case as a whole, including matters of jurisdiction and admissibility. Unless I can be of any more assistance to you, that concludes our submissions for today.
Merci à vous. À présent, vous avez la parole, l'État requérant.
For final observations. President, honorable judges, I would like to put the scene now and try to answer within the allotted time. The first thing I would like to mention here is that we are not here making our submissions because this morning we have pleaded enough. In full humility, we hope that the honorable judges will be able to deliberate on the various arguments submitted. The second observation is that we note that in the manner of formulating observations, maybe it is better to move ahead the debate and deliberation rather than bringing new elements that were not mentioned in the oral hearing, or maybe it's better to say that nothing has to be added and not to say anything. The third comment I would like to make here is that the existence of a dispute, I think that we have demonstrated that enough. I'm not going to come back to it. We have demonstrated that it is a prerequisite to exercise the jurisdiction or no. So if it was the case, we have demonstrated it enough. So unless Rwanda says now that, for example, a Minister of Foreign Affairs can come over the weekend and come to Bunagwala or Kisangani, then go back to Rwanda, and therefore the views of the two parties will be in conformity. We should not be surrealistic. In fact, there is a confrontation and a radical opposition of points of views. Even if we follow the reasoning of Rwanda, and here I would like to refer to the case of Mafumati's, how Rwanda considers today that it was in conformity with Congo. On the 21st of November 2021, in fact, tensions were prevailing, and honorable judges will have time for appreciation. Before giving the floor to my colleagues, what I would like to mention here is that law should be the basis of civilization. When individuals and states have disputes, we have to refer to a given article and to also judges. And Rwanda never wanted to face the situation before a judge. Now, they are talking about the ICG, but if you go to the ICG, maybe there will be some waverings from their part. We have to take the extreme assumption and the hypothesis. If this case is not admissible, there are so many killings. So is there any amicable settlement when there is human life which is at stake? So they are destroying, killing, committing genocide on the Congo territory, and they avoid meeting or appearing before a judge. This is the reality. So how do we have such objection if Rwanda thinks that it has valid grounds to support what it's doing? All these waverings, dilatory maneuvers. So, in a nutshell, Honorable President and Honorable Judges, really, here we are mourning in Congo. We tried amicable settlement because we are professionals. Some of us have lost their families, and all the world is watching what is happening. We can provide you with videos and press articles. How can we hear now that there is no dispute? Humbly speaking, I think that the court cannot follow Rwanda on this ground. So now, with your permission, I would like to give the floor to Professor Silva for 5 or 6 minutes, who is going to raise some of the concerns raised by the opposing party, and because the elements raised now were not provided for in their submissions, because these are their strongest arguments. Rwanda wants to be like a winner in Congo, because even they bury women who are still alive. They massacre and rape mothers, and now they come and say that these are not acts committed on the Rwandan territory, and so they cannot be sued. This is what Rwanda is saying. So now they are grasping, or rather they are sticking to the argument of extraterritoriality. So, Honorable President, kindly give the floor to Professor Marche Chokola, who is going to talk about a number of issues in relation to what was raised by Rwanda. Thank you. Honorable Vice President, President of this sitting, Honorable Judges, since it's the first time that I'm taking the floor within the framework of this procedure, I would like to thank you for giving me the floor, and I'm going to dedicate my words to some assertions made by Rwanda in the morning and in the afternoon. I will start with the last point, taking into account the fact of the time allotted. So Rwanda has talked about this issue, and I'm going to raise a point. So what we have heard is that we have affirmed that this hearing will not be dedicated to issues of jurisdiction and admissibility. But what is not mentioned from the other side, Honorable Vice President, is that they forget to say that this hearing is divided into two stages, two parts, according to the protocol established by the registry today and tomorrow. And today is dedicated to jurisdiction, and tomorrow we are going to present our submissions regarding admissibility. So we'll make oral presentations on that. Mr. President, Honorable Vice President, Rwanda has raised new elements which were not submitted before in their different submissions nor in the oral presentation. It is the so-called confusion between the territorial jurisdiction and the personal jurisdiction. In fact, Honorable Vice President, all the submissions of Rwanda never mentioned anything about personal jurisdiction. As far as we are concerned, we consider that personal jurisdiction is linked to the person that has a capacity to sue, or the person who can be brought before your jurisdiction. Trying to relate an issue of territorial jurisdiction to personal jurisdiction, while the DRC knows about all the theoretical data and elements, is a wrong path to follow. So this confusion is done in such a way that Rwanda tried to talk about the capacity to file a case before the court. The second element is to consider that the court cannot, and there is no reason for that, the court diverges from the practices of other instances regarding jurisdiction and admissibility. Honorable Vice President, honorable judges, we believe that this court is a specialized jurisdiction, specialized in Africa in terms of human rights. So it is not necessarily held to follow all the practices existing in other jurisdictions, simply because of the specificity of its jurisdiction, the territorial jurisdiction, and in view of even the cultural differences existing between some jurisdictions and the African Court of Human and People's Rights. As a specialized jurisdiction in terms of human rights in Africa and not elsewhere, not in America or in Europe, it has its own rules of procedures and rules that can permit it to diverge from the practices of other jurisdictions. The other elements I would like to raise here is the one linked to the similarity invoked by Rwanda between the provisions of Article 38(1) of the Statutes of the ICJ, the International Court of Justice, and Article 3 of the Protocol, 3(1) of the Protocol, that requests the court to apply the procedure before the International Court of Justice. I would like, with your permission, and as a reminder, that Article 38(1) of the Statute of the International Court of Justice provides for, quote, the court which mission is to settle in conformity with international law the disputes submitted, implements the status, quote, conventions, either general or specific, establishing the rules expressly recognized by the states parts of the dispute. And Article 3(1) of the court, 3(1) of the statutes establishing the court, indicates that the court has jurisdiction to examine all matters and dispute referred to it regarding the interpretation and the application and enactment of the Charter, Protocol, and any other relevant instrument relating to human rights. When we invoke evoke the title of these provisions, it seems without any doubt that there is no similarity between the two provisions, and this led to the adverse effect, according to the oral submission of Rwanda, that we have heard not pleadings on specificities of human rights that should mark all the reasonings and developments and international disputes of human rights, and this similarity, the so-called similarity which they try to establish, has led Rwanda to remain and to dwell on the, some facts evoked before jurisdiction on these or oral submissions. This in a nutshell, Honorable Vice President, Honorable Judges, the elements of answers I wanted to raise, which you will certainly appreciate when you will you are going to deliberate on our submissions. And I pray you, Vice President, to grant the floor to Advocate Marcel Nguma, who is going to close our submission this afternoon. Thank you very much. Honorable Vice President, Honorable Judges, we have developed our arguments, and I do not think that it is necessary to come back to them again at this stage. We are going to provide our notes and briefs to the court so that you better understand the substance of our submissions. It seems that there is a misunderstanding regarding the position of the DRC regarding the issue of territorial jurisdiction, and this transpired from what Rwanda said. To be brief, I would like to confirm here that for the DRC, territorial jurisdiction of the African Court of Human and People's Rights extends beyond borders of the respondent states. And as indicated before in our submission, we have 4 main arguments. The first argument is based on the drafting of Article 3 of the protocol to the African Charter of the Human and People's Rights, establishing the African Court of Human and People's Rights. When you read this article, one thing transpires clearly. It is the open formulation and the general nature of its formulation. This is not done by chance. We have carefully tried to consult the texts, the doctrine, and the opinion supported by Judge Kumambai, and his position is valid regarding Article 3 of the protocol to the African Charter of the Human and People's Rights, establishing the African Court on Human and People's Rights. Beyond that, and beyond Kumambai, there are so many authors that address this issue the same way, including a member from the African Court of the Human and People's Rights, I quote, namely Judge Chinkal, on this matter. This is the first argument, but it is not the only one. The second argument, as we have indicated before, is relating to the jurisprudence of the African Court of Human and People's Rights. We referred to 2 judgments where it appears clearly that the jurisdiction of the court could not be limited to the territories of the respondent state, but rather goes beyond. I'm not going to quote all these judgments since I did it this morning. Beyond these judgments, there are other judgments that seem not to be clear enough given their drafting and expressions used there. Maybe you can find judgments where the court says that it is competent because violations of human rights were committed on the territory of the respondent state. And you have seen that regarding Rwanda, it focused only on this wording. While if we take into account the whole set of jurisdiction of the African Court of Human and People's Rights, it's not the same drafting of the provision. In some judgment, the court says it is competent because the violation were occurred in the respondent state territory, but there are other judgments where the same court bases its jurisdiction on violations committed on the territory of a state party, and in this case the respondent state. Also, there is judgment Borna, and the question was asked to Rwanda on this, and judgment Borna has developed and advanced the issue of human rights, and we have demonstrated there is no obstacle why we should not affirm, why the court should not reaffirm its jurisdiction on the basis, the wrong basis, that the facts were not committed on the territories of the respondent state. I would like to mention the fact that Rwanda did not even mention this judgment, which is really fundamental given this matter. Now, are we going to expand on the jurisprudence of the African Court, which in fact had to decide on this a similar question when the RC has introduced a matter opposing it to Burundi, Uganda, and to Rwanda. There was a decision very well known by Rwanda, and I don't see why the court would not be aware of such a precedent. Now, the fourth element is based on the Article 3 of the protocol, establishing the Court of Human and People's Rights, and the reasoning is very simple, Mr. President. I think that you will certainly ask this question when you will deliberate. The problem is very simple. What is the signal sent to the African states? Because if the court follows the position of Rwanda, it means simply that respecting human rights, you should respect human rights as long as you are within your territory, national territory, but you have the green light to go elsewhere and violate human rights. This is what will be entailed if the court doesn't take into account the wording of Article 3 and its own jurisprudence, as we have mentioned, in addition to the jurisprudence of the African Commission of Human and People's Rights. I would like to conclude by insisting on the fact that we should not separate these four arguments because they have to be taken together. They are complementary to each other. And as you know, there is a perfect harmony between all of them. This is, in a nutshell, the additional information I wanted to raise. I do not know whether one of my colleagues would like to add something. Since this is not the case, I just have, on behalf of the delegation of the DRC and the Council of the Democratic Republic of Congo, I would like to thank you once again for holding this public hearing and for granting us time to express our position. Thank you very much. Final observation of the respondent state and observations of the applicant have been heard now. So Do you want to take the floor? Okay, over to you. Anything else to add? Yes, you have the floor. Honorable Vice President, I would like to indicate to the court that yesterday we had the similar incident where Rwanda sent its rejoinder after we sent our submission, and we had to react to its rejoinder, and we know exactly the interpretation. In fact, we could have insisted on this argument. So we believe that we have reached now the end of the hearing according to the protocol established. So when a party takes again the floor, it has derogated to the procedure. And this morning we had a pre-audience. Maybe we can also have another one to talk about these issues, because here we are seeing new elements they are raising by trying to discredit a submission and a pleadings, because we cannot plead on objections before without putting the stage of the context of any matter. For example, a number of elements were objected to. How to demonstrate there is a dispute if we do not put the context in which the fact occurred? It means simply that we can consider that what the agent said is a simple declaration with no effect on the proceedings. But if need be, tomorrow we are ready to meet in a pre-session in the same format to tackle other issues. Thank you very much. Tomorrow we are going to resume our hearing at 9 o'clock. The hearing will be dedicated to admissibility. This being said, the session is adjourned till tomorrow 9 o'clock.